All right. Court calls cause number 18-4906, State of Texas versus Hether Thomperson. Today's date is April 23rd, 2020. The Supreme Court of Texas and the Court of Criminal Appeals of Texas have issued multiple emergency orders regarding the COVID-19 state of disaster. At least one of these orders allows the courts to hold hearings remotely if possible. Therefore, this hearing is being held remotely via video conference. Please listen carefully to the following admonishments. Number one, absolutely no recordings of this hearing are to occur by anyone participating or watching from the public. The only record of this hearing is to be taken by the official court reporter. Anyone violating this instruction may be found in contempt of court. Number two, this hearing is being broadcast via live stream to the court's official YouTube channel in order to comply with the Texas Open Courts provision. Announcements, please.
State's President, Your Honor.
Defense President, right here.
Very good. Ms. Thomperson, can you hear and understand me?
Yes, sir, I can.
Please raise your right hand. You solemnly swear or affirm testimony you give in this case will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Go ahead and put your hand down. Ma'am, are you Hether Luella Thomperson?
Yes, sir, I am.
Is that your true and correct name?
Yes, sir.
Ma'am, can you speak, read, and write in the English language?
Yes, sir.
Are you a United States citizen?
Yes, sir, I am.
I need to let you know that if you're not a United States citizen, your plea of guilty can and will result in your deportation, exclusion from this country, and or denial of naturalization benefits. Understanding that, would you still like to proceed?
Yes, sir.
Ma'am, have you ever had any mental problems?
No, sir.
Okay. Counsel, do you believe that your client is competent to stand trial?
Yes, sir.
Ma'am, are you satisfied with the representation you have received from your attorney?
Yes, sir, I am.
Counsel, have more than 10 days passed since you were appointed in this case?
Yes, sir.
And has your client received a copy of the indictment in this case more than 2 days ago?
Yes, sir.
Do you and your client waive a formal reading of the indictment?
Wait here, y'all.
Ma'am, I do need to let you know that you are charged by indictment. Give me 1 second. There it is. You're charged by indictment with the offense of possession of a controlled substance in penalty group 1 in a drug-free zone. As charged, this is a third-degree felony. Ma'am, do you understand the charge as it appears against you in the indictment?
Yes, sir, I do.
Now, as I stated, this is a third-degree felony. The range of punishment for a third-degree felony is no less than 2 years, no more than 10 years in the Texas Department of Criminal Justice Institutional Division, and a fine not to exceed $10,000. Ma'am, do you understand the range of punishment for a third-degree felony?
Yes, sir, I do.
Then, understanding the charge as it appears against you in the indictment, as well as the range of punishment, how do you plead, guilty or not guilty?
Guilty.
Ma'am, are you pleading guilty freely and voluntarily?
Yes, sir, I am.
Has anyone promised you anything other than the potential plea agreement from the state in order to get you to plead guilty?
No, sir.
Has anyone threatened you, forced you, or done anything unlawful to you to get you to plead guilty?
No, sir.
Has anyone promised you an early release from your sentence?
No, sir.
Then, ma'am, are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
Ma'am, if you'll give me just a moment, I am going to try to bring up a document. Okay, document should have just appeared on your screen. Has the cause number at the top, has your name right here, and it says guilty plea memorandum. Do you see that document, ma'am?
Yes, sir, I do.
Okay, I'm going to go ahead and scroll down to the third page. And I will ask you right here, as well as right here where it says defendant, is that your signature in each of those spots?
Yes, sir, it is.
Very good. And next, I'm going to scroll one more page. This is the stipulation of evidence and testimony. Ma'am, is this your signature right here?
Yes, sir, it is.
Ma'am, do you recognize both of these documents?
I do, sir.
Did your attorney go over them with you?
Yes, he did.
Did he explain them to you?
Yes, sir, he did.
Did you understand them?
Yes, sir.
Is everything that's contained in these documents true and correct?
Yes, sir.
Counsel, in regards to both the guilty plea memorandum and the stipulation of evidence and testimony, did you in fact go over both these documents with your client?
Yes, Your Honor.
And did she appear to understand them?
She did, Your Honor.
Ma'am, I'm going to go ahead and ask you a few more questions about these documents. Did you understand when you were reviewing and signing them that you would be agreeing to waive or give up certain rights?
Yes, sir.
Did you know that you're giving up your right to a trial by jury?
Yes, sir.
Did you know that you were waiving your right for your attorney to be able to cross-examine any witnesses against you?
Yes, sir.
Do you understand you were waiving your right to remain silent?
Yes, sir.
Did you understand you were giving up your right to not be compelled to give evidence against yourself?
Yes, sir.
And finally, ma'am, did you understand that there are other constitutional and statutory rights that appear in these documents and that you were waiving or giving up those rights when you signed them?
Yes, sir.
Then, ma'am, I will find that you do understand the consequences of signing both of these documents. Counsel, does your client understand the nature and consequences of a plea of guilty?
Yes, Your Honor.
Ma'am, I find that you are presently competent to stand trial and that you are not influenced by any consideration of fear or by any persuasion prompting you to confess your guilt. The court accepts your plea of guilty at this time. What evidence does the state have to present?
Your Honor, the state would offer the defendant's guilty plea memorandum and stipulations as State's Exhibit 1.
No objections, Your Honor.
With no objection, State's Exhibit number 1 is admitted.
State rests, Your Honor.
Defense?
Judge, just briefly, Heather, we talked a little bit about particularly the drug-free zone and what that would mean potentially if for some reason something happened down the line. We've talked about the plea bargain involving everything else. Do you have any questions on the plea bargain?
No, sir.
There's nothing further. We rest and close.
Very good.
State closes and we waive a PSI.
Does the defense waive a pre-sentence investigation report?
We do, Your Honor.
Does anyone object to proceeding with sentencing at this time?
No, Your Honor.
No, Your Honor.
With no objection, we'll proceed with sentencing. The defendant has pled guilty to, there it is, the charge of possession of a controlled substance in penalty group 1 in a drug-free zone. What is the plea agreement?
Sorry, Your Honor. In exchange for the defendant's plea of guilty, State is recommending 5 years deferred adjudication, a $500 fine, $290 in court costs, $600 in reimbursement fees for the court-appointed attorney fee, restitution in the amount of $180, 200 hours of community service restitution, and a sweat patch. The $180 restitution is made payable to the Texas Department of Public Safety Crime Lab.
That is our understanding, Your Honor.
All right. Ma'am, let me ask you directly. Were you able to hear the plea agreement as it was read into the record by the state?
Yes, sir.
Did you understand it?
Yes, sir.
Is this your understanding of the plea agreement?
Yes, sir.
And are you asking me to approve this plea agreement?
Yes, sir.
And ma'am, let me ask you a couple more questions. You understand that if I approve this, that this is for what's called deferred adjudication probation. Has your attorney explained to you the good and the bad, the pros and the cons of deferred adjudication? Ma'am, can you hear me?
Yes, sir.
Has your attorney explained to you the good and the bad of deferred adjudication?
Yes, sir.
Okay, so the good news is, what happens if you do everything you're supposed to do and you successfully complete your deferred? What happens?
It should be taken off of my record, right?
Okay, well, let me correct you. The case would be dismissed, okay, because even though you've pled guilty, there would be no finding of guilt. Just so you understand, the case doesn't just magically disappear from your record. Do you understand that?
Yes, sir.
Okay, but you would not have been found guilty, so you would not have a felony conviction. Is that your understanding?
Yes, sir.
Okay, that's the good news. What's the bad news? What happens if you don't do what you're supposed to do?
Could do 2 to 10?
Okay, so you do understand that you are subject to the entire range of punishment, which means up to the maximum 10 years. Is that correct?
Yes, sir.
Okay, and understanding that, is this still what you want to do?
Yes, sir.
Ma'am, are you currently employed?
Not at the point.
Okay, and is that because you're in jail right now?
Yes, sir, it is.
Are you capable of working?
Yes.
All right, so you're not disabled or anything like that, correct?
No, sir.
Okay. So, ma'am, do you understand that part of the terms and conditions of your probation will be for you to make monthly payments, probation fees, paying back court-appointed attorney's fees, the fine, court costs, etc. Do you understand that there will be monthly payments that will be due as part of the terms and conditions of your probation?
Yes, sir.
And are you telling me that you do have the ability to make those payments?
Yes, sir.
All right. Then with that, ma'am, I will go ahead and let you know that I am going to approve your plea agreement at this time. Therefore, the court finds that the defendant has entered a guilty plea in this case voluntarily. The defendant was competent to make such a plea. There was sufficient evidence supporting the defendant's plea to find the defendant guilty of this crime beyond a reasonable doubt. However, the court defers any finding of guilt and places the defendant on unadjudicated probation or community supervision according to the exact terms and conditions of the plea agreement as they were read into the record by the state and agreed to, ma'am, by both you and your attorney. Is there anything further from the state?
No, Your Honor.
From the defense?
No, Your Honor.
Okay, and ma'am, just before we began the hearing, before we went on the record, the probation officer, Liz Vasquez, who is also in attendance of this video conference, she did give you her telephone number. You wrote it down. And do you understand that you need to contact her? You need to call her tomorrow. Do you understand that?
Yes, sir, I do.
Okay, that's an order from this court. So I'd hate for you to not do that and already be violating your probation. Ma'am, do you have any questions?
No, sir, I don't.
All right, very good. Then with that, we are in recess. And good luck to you, ma'am.
Thank you, sir.
You're welcome.